we're working on it, and we're going to try to get the best education possible to you, given these changing circumstances. In terms of how the changing circumstances are affecting your ESD, you also know that ESDs are required to meet once a month. That's a statutory requirement. In normal times, that's not a very big deal. You have your monthly meetings and you're used to that. Of course, these are not very normal times with the coronavirus and the COVID-19 disease that it's causing in this outbreak. Here tonight to talk about some of the proclamations that have come out, some of the changes that have been made and allowances that have been made is someone who needs no introduction, coming live from his office, Mr. John Carlton, a frequent presenter at safety events and on these webcasts. And basically, we're just going to turn it over to him and let him take you through some of the legal changes that have been happening and how they affect your ESD in light of this virus outbreak. So, John, I'm just going to kind of let you go with it.
Thanks, Clay. Well, it's good to hopefully see everybody tonight, although I can't really see you. We're going to go over how the coronavirus is changing both your open meetings requirements and your maybe some other operational issues. It's been a rapidly changing circumstance. So I'm just going to go through the history a little bit. December 2019, novel coronavirus was detected in China. January 30th, WHO says that outbreak is a public health emergency of international concern. March 5th, World Health Organization urges aggressive preparedness and activation of emergency plans. March 13th, the president issues a proclamation on declaring a national emergency concerning the novel coronavirus disease. On that same day, the governor of Texas declared a state of disaster. We're 10 days later now. But in those 10 days, on March 16th, the governor issued suspension of certain provisions of the Open Meetings Act. On the 17th, the governor activated the National Guard. On the 18th, the governor issued a proclamation allowing postponement of local elections. On the 19th, the governor issued an order to limit gatherings to 10 or fewer, close schools, bars, restaurants, all the public places in the state, and that was following guidance from the president. March 20th, the governor postponed the runoff primary elections, which were set for May 26th, kind of following his own advice on postponing other elections. Then on March 22nd, the governor issued an executive order increasing hospital capacity and announcing supply chain strike force for the COVID-19 response. And then just today, Dallas County ordered its residents to shelter in place. I understand that's the first of several cities that are going to do that throughout the state. Let's look at the numbers across what's been happening. So remember, this started in December of 2019 in China. There are now over 300,000 confirmed cases, over 14,000 confirmed deaths in 190 countries with cases of COVID-19 caused by the novel coronavirus. In the U.S., there are now 33,000 cases and 400 deaths in all 54 jurisdictions, the 50 states and the 4 districts. That information is from the U.S. CDC. The growth has been pretty dramatic over the last 2 to 3 weeks. The chart that I got from the state health services shows where we're headed. Those numbers that are tailing off on the back end don't include reported illnesses from March 15th through yesterday. So in Texas, we have a total of about 10,000 people that have been tested. Not really sure on the private lab number, but that's the estimate right now, with a total of 352 cases as of noon today and 8 deaths as of noon today. That's from dishes. What does that mean? Well, we have several issues that are resulting from the COVID-19 pandemic. We've got some continuity of operations or continuity of function. That is why we're here talking about how you continue to operate during this. There's Open Meetings Act compliance. I'm going to throw in some information about Public Information Act, conducting elections, things you ought to consider on revenue impacts, and how you can help your providers make sure they keep their resources up. because we're going to be in this for a little bit. But in general, here's my recommendations. You need to contact your legal counsel to get you through this process. This presentation is in no way a substitute for getting your own legal advice from your legal counsel. And I can't emphasize that enough. We are in a situation where things change daily, if not hourly. I'm pretty much glued to everything that's coming out, trying to make sure that we keep up with how to change operations to address the current disaster. You can contact your DISH's regional and local health operations for more information on how to get access to the governor's supply chain strike force. That was some information that Safety was able to acquire today. And then I highly recommend you stay in constant communication with your chief to make sure he's got the resources, he or she has got the resources to utilize in the response. I've had some conversations with a couple of chiefs. The other thing I want to recommend is you need to stay on your core functions. Try not to get distracted with the other stuff. Remember, your emergency response providers. You need to be able to respond when people pick up the phone and dial 911. You don't need to be involved in crowd control or any other types of issues. It's going to be a challenge enough as it is with your core services. So let's talk about the Open Meetings Act. What's going on there? Well, effective March 16th, the governor suspended a limited number of provisions in the act. And his comment was it was only to the extent necessary to allow telephonic or video conference meetings and avoid congregation in physical locations. Excuse me, those waivers are in effect until this disaster declaration is lifted or expired or the governor terminates it. So this is the new way we can operate. Essentially, we have provisions that require a quorum or a presiding officer to be physically present at a specified location. Those have been suspended. Any provisions that require physical posting of the notice have been suspended. Provisions that require that a telephonic or video conference meeting be audible in the meeting location have been suspended. And provisions that may be interpreted to require face-to-face interaction between members of the public and public officials have been suspended as well. How were those suspended? Well, remember, the Open Meetings Act generally requires you to give 72 hours notice of a meeting. That's still in place unless there's an emergency, and it's a little difficult to decide what's an emergency in this situation, but in general, you're still talking 72 hours. The notice or the agenda still has to state the time, date, and place. Now, that place may not be a physical place. That place may be a webcast or a telephone conference. But you are still able to post your agenda with the county clerk at the county or on your website and at the ESD administrative office. That's kind of the normal operation. You can continue to do that if that's feasible for you, but the governor's suspensions have given you some other alternatives. The notice has to sufficiently describe the matters you're going to talk about. And the public, while they normally would have a right to attend, now they've really kind of got a right to participate, not necessarily attend in person. So what were those suspensions? The physical requirement to post notice is not in place anymore. You can, it is an option for you to post notice, but it is not required that you physically post notice. If you choose not to post notice in a physical location, there are some requirements that come into place, and that means your notice has to have whatever the toll-free number is to dial in so people can listen to your meeting, or free of charge video conference link for people to watch and hear your meeting. And you have to provide with your notice of the meeting an electronic copy of any agenda packet. So any materials that go with your agenda, they have to be out there. So while there's some enhancements to being able to not post physically, there are some requirements that come with it. If you do post physically, which you can still do, and we're going to talk about my recommendations on that in a little bit, then those extra items are not required. I will note, though, that if your meeting is being held solely over video conference, that your notice has to include the telephonic or video conference link, regardless of any physical posting. And when I say solely over video conference, I mean there is nobody at a physical meeting location for the public to interact with. So we'll talk about how that kind of plays out. So the governor also suspended some portions of the law related to video conference calls, and it essentially permits a video conference call meeting to be held without a meeting location and without a quorum at a particular location. Under the general rules, a quorum is required to be at a particular location in order to have that video conference happening, but that is not required under the suspension. Now, the quorum does have to be maintained throughout the length of the video conference so that everybody's participating either telephonically or by video conference in the meeting. You can't continue your meeting if you don't have a quorum. There is a caveat to that I will note, but we'll talk about that in a second. It does also suspend the requirement that those video signals be available or present at a meeting location. So whereas in the past, if you were broadcasting the video meeting, you had to be able to see those at your meeting location, you no longer have that requirement. So I told you a little bit about the quorum requirements, and what's interesting is under the Government Code, Chapter 418, there is a provision that says that a quorum of a government body is not required for the governing body to act if, and there's two conditions here, the entity's jurisdiction is wholly or partly located in an area of a disaster declared by the President of the United States or the governor. That, in fact, is the case. So we are meeting the first condition. The second is that a majority of the members of the governing body are unable to be present at the meeting of the governing body as a result of the disaster. Now, given the governor's changes and the ability to meet by teleconference or video conference, that provision means that if those members are unable to participate by video or telephone conference, I would argue you could act with less than a quorum. But you have to not be able to actually participate by telephone conference or video conference in order for this provision to come into play. So let's move a little bit to public participation in these meetings. Well, the governor has altered how public participation is handled. Telephonic or video conference meetings now need to be are generally required to be audible at the location of the meeting. But the governor suspended that requirement but two things have to be in place, and a third has to occur at the end. One, there's got to be a dial-in number or video conference link in the notice of the meeting that's audible to members of the public. So people have to be able to call in and listen or watch on video conference. And that link has to allow two-way communication. So folks have to have the ability to participate by speaking into the meeting somehow. And then third, the thing that has to happen after is a recording of the meeting has to be made available later. There's a number of different technological processes that can be used to accomplish this, either telephone conference bridges or video conferencing software and such. But those are the requirements in order to do your meeting. If, however, you provide a location for the public to attend your meeting, to listen or participate, then you don't have to provide the dial-in number, the video conference link, but you will have to comply with all the regular rules for telephone meetings or video conference meetings. And let's go through those regular rules. Telephone conferences are a little bit different. So you can hold a meeting by telephone conference only in any circumstance, even under the governor's waivers or suspensions, only if an emergency or public necessity exists, which I would argue one does under the governor's declaration. And two, it is difficult or impossible to convene a quorum at one location. Given the suspensions on gatherings right now, one could argue that in some circumstances it wouldn't be difficult or impossible to get a quorum in one location. But if some people are required to shelter in place or they've been diagnosed and they can't leave their house and you can't then get a quorum as a result of that, then you can have your telephone conference. The suspension that the governor issued didn't affect these requirements for telephone conference meetings. So although both conditions are likely satisfied or likely to be satisfied as we move forward, I want you to keep that in mind for telephone conference calls. Now, with respect to the general rules, telephone conference calls are required to you have the usual notice requirements, and they've got to be held. Those meetings have to be held in the same place, and the identity of the speaker has to be clearly stated before anybody talks. Those things, other than the second two there, that the meetings be in a place of regular meetings, and the identity of the speaker clearly stated, those have been waived by or suspended by the governor's proclamation, but the first one has not. There's some other general rules. The meetings have to be set up to provide two-way communication. Governor's suspension doesn't affect that. People have to be able to participate. And all portions must be audible to the public. So the governor's proclamation and suspensions don't affect that requirement either. And then the meeting has to be tape recorded and a copy made available to the public, which the governor has essentially restated in his proclamation on this as well. So telephone conference call can be done. Need to really make sure that you focus on that it's difficult or impossible to convene a quorum at one location. If that's the case, then your telephone conference call can happen in place of a regular meeting. Let's talk a little bit about video conference calls now. So the general rules on video conference calls is that they were allowed if the presiding officer was present at the location of the meeting. And then that members of the body and employees participating by video conference had a live feed or audio feed. The public had the ability to attend the meeting at the place, so that there was a camera and a microphone that allowed them to communicate with the other board members. And essentially the public communication had to be allowed as though there weren't video conferencing occurring. Well, those same things, the notice had to specify the same, or has to specify all the information. Everybody's got to be clearly audible and visible at all times. And you got to meet some video and audio requirements that are set out by the Department of Information Resources. And then you have to at least make an audio recording available. Several of these have been suspended as a result of the governor's actions. And so essentially he suspended the requirement that each member of the public has to get to speak on an item. So y'all remember in this last session, there was a provision put in that said, hey, everybody gets to talk on every item on the agenda before there's any action. That's been suspended. The governor said, though, provided that there is an alternative method of communication with public officials. Now, there's no explanation as to what that means. Perhaps that is they get a chance to, send in email comments or have another way of communicating about items on the agenda. But there does need to be some alternative form of communication. I know I'm flying through this, so I thought I'd condense it down to some key points on the Open Meetings Act, and I've broken this for each section. So key point number one, post your notice or your agenda physically, if it's possible. If you post it physically at your administration building, then you can post it electronically on your website and avoid having to deal with some of the added restrictions or requirements of the governor's suspensions. But I do recommend that you include a statement on your agenda about public participation. Essentially, you want to make sure the public knows how to communicate with you at these meetings. If you have a meeting at a physical location and the public shows up and you don't want them to come and create a gathering at your meeting location, they need a way to participate. So they need a telephone conference line, they need a video conference web address, something like that, and that needs to be provided in the notice or the agenda. If it's possible, you need to designate one commissioner to attend the meeting at the location specified in the agenda. I think that will really simplify things in terms of worrying about complying with all these rules. If that commissioner goes and then posts a notice, essentially I'm calling it an extra notice, outside the building that says, hey, you want to participate, call this number and you'll get to hear all of our conversation, or you want to participate, log into this website and you get to be there in the meeting. That helps you avoid those gathering restrictions. In any case, record your entire meeting. And a lot of times we talk about, well, do you really want to record a meeting? Sometimes yes, sometimes no. During the duration of this disaster, I'm recommending you record the entirety of all your meetings, except for your executive sessions. That just needs to be out there, and you need to hang on to it and make it available to the public. All right, so I'm going to move on to the Public Information Act. I'm going to try to leave us time for some questions at the end, unless, Clay, you've got some questions already and we can deal with those.
Yeah, I got a couple
that
we may want to knock out while we're still fresh on the open meeting stuff. Okay, first one. Can we hold emergency meetings right now for general stuff like contracts? We had a computer there in case anyone wanted to watch, but nothing given prior before the meeting. The board all met, but we didn't allow the public in to avoid 10 people gathering. Is that okay? It's very fact specific, and I know you can't render.
Yeah, so remember the very first thing I said, you need to be talking to your legal counsel, and you need to be getting their guidance all the way. I've been on the phone constantly with clients, helping them work through this process, trying to get there. I'm going to stay away a little bit from the fact scenario of that specific question. I'm going to go first back to emergency meetings. Remember, an emergency meeting is not something that is of your own self-creation, and it's really something that requires urgent action. In general, despite the feeling of this disaster, I would say that there's not an emergency that a board for an ESD meet immediately, unless there is some sort of equipment that you've got to have that you just don't have time to get any other way, that all of a sudden is a new sort of issue. Otherwise, you've got 72 hours to post a meeting and conduct a meeting, and we'll talk about how you can give your chief the authority or give some authority to someone to conduct district operations so you don't have to be constantly having the board meet to deal with kind of unforeseen circumstances. I've got a little bit of information on that later. With respect to the details of how they did their meeting was compliant, I can't really speak to that because I haven't seen the postings. I don't understand. And without looking at the notices, I can't give any legal advice on that. That's for their counsel to do. I would say, however, that the governor's position on agendas and notices is you got to put everything on the agenda. If you're going to meet by video conference or telephone conference and not post your agenda physically, you have to have those telephone numbers or that website on your notice before you meet. And so if you meet physically in a location and you don't have those notices, then I think there's some wiggle room there that you might be able to allow the public to participate by other means without having had that information on your notice. But you really need to consult with legal counsel.
Okay. I think this was the same person. They said we didn't give any links, just if people showed up, then we would let them see what we had going on.
So the key there is they have to be able to participate, right? And participation under all of these circumstances, whether it's regular rules or these, means they have to be able to communicate with you, whether that's telephonically or through a video conference link or in person.
Okay. We got a bunch of questions. So let's move on. What is the definition of record? I believe it's record, not record, that there's, what is the definition of record for the telephonic or video meetings? Are written minutes sufficient?
Written minutes are not sufficient. Recording does not mean writing minutes. It means recording the meeting. Audio recording would be sufficient.
Where someone could go listen to it or watch it? Okay.
Yes.
Is a toll-free dial-in number required if the video conference is free?
If the video conference is free, I don't believe there's a toll-free dial-in that's required. It's kind of an either-or thing. You can video conference, or you can do the telephone conference, or you can do a blended sort of thing. There are some differences. If you're solely going to meet by video conference, remember that solely meeting by video conference brings with it a couple of requirements. I'm going to try to get back to that slide. And when I say solely, then the notice has to actually include that video conference link. So be aware of that.
Basically, it has to be free to access, right? And so they're saying
Correct.
make them dial a long distance number to get into that conference call.
Correct.
Okay. Let's see. Okay, this is one that we had actually asked a while ago by our good friend Vernon out in Limestone County. They don't have the bandwidth nor the cell strength at their main station ESD office to do a video or an audio. Landline is only capable of doing 3 to 4 on a conference call. Do you have an answer for them that I mean, let me go ahead and take my shot at this. I think this is more of because I think a lot of rural ESDs are going to be in this situation where you may not have the bandwidth to do a full broadcast, but I think it's going to come to, you got to find some sort of conference call where you're not having to have the call on your phone where you have 3 or 4 lines.
Right.
But there are services where you can call in and multiple people can call in from multiple locations, right?
Yeah. So technologically there, I mean, you know, you can choose to meet in person and deal with a quorum at the meeting location. Or you can choose in that situation to use your landline to call a teleconferencing service, which is what you're talking about, that allows people to call in from their own phones to that teleconferencing service, and then it's not chewing up anything other than your one landline.
Right. I mean, it's all a matter of being. You can do this remotely, right? Where
yes.
We are meeting via Zoom right now, and the bandwidth is only matters in terms of the one connection you have from one different location. Then you at your office have a different connection, different bandwidth. So it should be, you know, and that's video. I understand if folks are on dial-up, but right. In terms of the conference call, that's a little easier because there are services where you can call in just from your particular location, call in, and everybody calls into that number. And it doesn't matter what your phone at your office can handle. It's just one person calling into one line. But yeah, I mean, that's going to be on everyone to kind of try to shop around and find those solutions, right?
Yeah. So there are actually really several options for that you can get to fairly easily searching the web, but. You know, most of the video conferencing services actually allow a teleconferencing as part of what they provide too. So there's a number of different ways. And in fact, I've had meetings so far where we've had blended telephone conference and video conference as a result of the various, you know, technologies that can be used. So.
Right. Let's see. From a public health perspective, it would clearly seem best to have no physical aspect to meetings. But as I understand it, it's your recommendation that there be a physical element, even if most commissioners are on a teleconference or video conference.
And the only physical aspect I'm suggesting is that one commissioner be at a meeting location. That's it. So there's no interaction with them for anywhere else. Now, if you don't want to go there, you don't want to do that, you want to be more conservative than that. Then you've got to go in and comply with these requirements for having a fully virtual meeting. Okay,
we're getting a ton of questions. This is the most questions I think we've ever had. I saw the notice from the state, we must allow 500 to 1,000 attendees. We've never had more than 5 attendees. Is the state guideline absolute? I guess virtual attendees is what you have to provide for. Do you know what this person's asking about?
So the issue is, what's the capacity of your conference call line or your video conferencing capability? What I would say is that you need to have capacity for everybody that wants to participate, whatever that might be. And that's going to be a risk evaluation for every one of you, and you need to talk with your legal counsel about how much you need to be prepared for.
Okay, we posted notice on Friday for regular monthly meeting to be held Wednesday. Stated meeting, I'm going to try to suss through this to find a non-fact specific element to this question, because like John cannot answer fact specific questions and give legal advice. It's very dangerous to do. stated may be held via teleconference, but did not have teleconference number at the time. Can you add the number to the notice and on the website and hold teleconference meetings without a physical meeting site? So that's kind of the thing, right?
So, the requirement is that if you're going to have a meeting without a physical presence, you've got to have those things in that notice as it's posted. So, if you haven't done that, I think, you need to rethink how you're handling your meeting.
So you got to have it 72 hours ahead of time. So if you
Correct.
posted, okay, so this is where the fact comes in. Posted Friday, regular meetings Wednesday, which I guess is this Wednesday. Could they go back and amend that notice to add those numbers is basically what?
So as a general matter, if you amend a notice, it starts the clock again for anything you add to your meeting. So an amended notice less than 72 hours is not sufficient notice for that meeting.
Yeah, so that's a sticky one. I mean,
they need to be talking to their legal counsel about how they figure that one out.
How do you handle an executive meeting when it's a phone conference? That's a good question.
An executive session?
Yeah, how do you do
a closed meeting?
Right.
That is a good question. I have not looked at the technology of how to parse out folks from that kind of a situation, but it might be as simple as having a second conference call that happens while the other one is on hold.
That seems to me like it'd be the easiest way to go about it. But some of these technologies, and I know, thank you all in the comments who are sort of, safety can't recommend a specific vendor or anything, but there's a lot of good chat in the comments about some people who've used different providers. Some of those technologies offer you the ability to sort of exclude folks and go into a private meeting.
Right.
But that's going to be on y'all to kind of figure out how that works.
Right.
The important thing is you can still have executive session using the same rules, right? That we always do. It's just
same. None of those rules have been suspended or waived or altered by the governor's actions.
Let's see. What else do we have? When somebody has to be when somebody has to be present, does it have to be a commissioner? Have we addressed that?
So my recommendation is that it would be a commissioner. I know what we're talking about, but as long as you have a board member at that location, that's a better position than just a contracted fire chief or one staff member.
Okay.
But once again, those are all, there's some nuances in all of these rules and the waivers and how they work together. You need to consult with your legal counsel about that.
But your advice is to try to make it a commissioner.
Yes.
When making a recording public, does that have to be on the website or is it upon request?
So it does not have to be on the website. It would be treated more like a public record where you would respond to that if folks want to have a copy. There's nothing in the governor's suspension or any of the information that's come out yet, I believe, that talks about where and how quickly that has to be available.
Okay, so and this is sort of this is more of a safety issue that for tonight's webcast. I understand some of y'all are in areas where you don't have a lot of bandwidth and you have satellite internet, and pulling down the video is difficult because you're pulling down a Zoom meeting through our broadcasting system. We may try to alter that to do an audio dial in. Safety's learning as well as to what we can do now. This is the first of probably a few where we try some things that aren't going to work. Again, a recording of this will be available. John's slides should be available somewhere in a link in an email that was sent to you. So hopefully you can get access to that. Do you have to post the recorded meeting on the website after the meeting, or just retain? Okay, you just answered that one about the recording. Okay, let's go ahead and move on.
All right. So a couple of bits of information. Like I said, things are changing quickly. Bexar County just ordered shelter in place, and we expect both Travis County to do the same thing tomorrow. So it's a rapidly evolving situation. It requires flexibility and lots of communication. So let's talk about the Public Information Act, because there were some questions about, hey, how do I deal with these meetings, with these recordings? So the Public Information Act, you may remember, generally applies to ESDs and volunteer fire departments and the service providers of the ESDs. You're required to respond to all requests in a reasonable period of time. There are exceptions to the act that you have a deadline to ask the Attorney General about. Those kind of things become concerning when we're operating in a disaster scenario. So how do we deal with those requests? Well, so here's some guidelines from the Office of the Attorney General related to Public Information Act requests right now. And I will say, I do not have a slide on it, but there is a way to declare an emergency that it lasts for up to 7 days, but only 7 days. And frankly, I don't think that route works in this circumstance, because I think we're in this for longer than 7 days. So what does the Attorney General say? Well, the Attorney General says, hey, here's how you calculate business days, because you have 10 business days to ask the AG for an opinion. The following days don't count as business days. Holidays don't count. Weekends aren't business days. And then we get to the interesting ones. Skeleton crew days. If you're at an entity where you don't have people with the ability to be in the office responding to records requests, that doesn't count as a business day. If you have a day where your administrative offices are closed, that doesn't count as a business day. Now, for a lot of our ESDs, the business of the ESD is those 5 board members. If you're ordered to shelter in place, I'd argue you don't have access to those records. That's not a business day, but you're going to have to document that somehow, so that when and if you have to ask the AG for an opinion, you can say, hey, we weren't open for business on these days. So if a governmental body has closed its physical offices for purposes of a public health or epidemic response, or if a governmental body is unable to access its records on a calendar day, then that day isn't a business day. Even if the governing body's, the entity's staff works remotely or is present but isn't involved in public health or epidemic response. That's what the AG says. So what do we need to do? Well, your key points are, if you're going to reduce staffing to skeleton crew days, that's probably going to extend the time for your response, but you need to document that, and you need to then let people know. So you've got to specify, if you've got administrative staff that are responsible for records and they are no longer essential personnel and they're not in the office and they can't answer requests, that's not going to count as a business day. So you've got to specify whether those folks who are working remotely actually have access to records. They probably don't in that instance. And then you need to provide notice to the public of your operation on a skeleton crew or your admin buildings being closed. That could be simply posting something on the door of your administrative office. It could be putting something on your website. Probably both would be better. And just say, hey, look, if we get requests, we're not going to be processing these until we're back to full administrative staffing or our administrative offices are open again. That will then count as the first business day for our response. That documentation is going to be important going forward, so you can focus on emergency response and not responding to requests for records. If you get a request for records, contact your lawyer, make sure they understand what's come in, and make sure you've got things documented so that you can show the Attorney General those were not business days. Let's turn a little bit to elections. So this disaster hit at an interesting time in American politics. We've got May elections coming up, and in general, you cannot cancel or postpone an election once you've called it unless it's unopposed. So if there's a board member election that's unopposed, fine, you can cancel that board member election generally. If there's a proposition, do we want to impose a sales tax? Do we want to increase our maximum property tax rate? Do we want to create an ESD? Those types of elections, once they're called, cannot be canceled because they are, by definition, opposed. There's no way to say it's unopposed. That was a real predicament. I was, in fact, talking with other lawyers, other ESD lawyers over the last week, and a lot of this presentation is as a result of those communications. So thank you. Thank you guys. I appreciate it. But the governor has, since that communication, authorized postponement of the May general election to November of 2020. Not any other time. You can move your May general election to November of 2020. The governor followed that, as I said early in the presentation, with a postponement of the May primary runoff election date, which was May 26th, until July 14th. And that July 14th date was the date of a special election to fill a vacancy in the Senate, in the Texas Senate. I don't know whether July 14th will continue to hold, but that's what's happening on elections as far as the ability to postpone. I've got clients looking at it going, but wait, we really need to have this election occur. I think you need to evaluate. This is a situation that's extraordinary, and we're talking about public health. Who are your election workers? Are those folks at risk for exposure? Do they really need to be out handling ballots for everybody? The state is not set up for virtual voting across the board. So what do you do if you're going to postpone your election? In order to postpone it, you need to adopt an order. That means you got to have a meeting, so you got to follow those procedures we were just talking about. But you got to postpone your election to that November 3rd, 2020 uniform election date. The order that you adopt to postpone should reference the governor's proclamation, confirm that any candidate filings that you've got remain valid, and that your filing period's not going to reopen, because we know that could be an issue later on. And that needs to confirm that you've got all of the applications for ballots by mail for those folks that are either that were applied for as a result of being over 65 or disability. You let those, that needs to confirm that those folks still, those applications are still good. But the folks who applied for an application for ballot by mail just because they weren't going to be in town, it was absentee. Those folks will need to submit new applications. You need to restate that in your order. The major dates that you need to be concerned about for the November election are voter registration deadlines October 5th, deadline to submit an application for a mailed ballot is October 23rd, and early voting is October 19th through October 30th. So what do you do once you decide to get there? Well, you got to revise your order of election. Do that sometime before August 17th, which is the deadline to call an election for November. And you need to make sure you change the date in your revised order, change the location. If you know of anything that changes, you probably need to wait to make this amendment to your order until you know this information. Same things on early voting dates and hours, and whoever the early voting clerk is, and then the branch early voting locations. Then you need to update your website and notify the media. You really need to post notice on your website and alert the media that you're changing your election date. Communication, once again, is key. People will understand if you let them know, but if you don't say anything, they're going to get pretty upset. Provide notice to the county election officer. If the county's running your election for you, you need to for sure let them know. There's also a requirement that you give notice to your county election officer, even if you're conducting the election yourself. And then provide a revised notice to the county so that they can post that about your election. If you're going to postpone your election, which at this point, I think the governor recommends that you do, and I recommend that you do, you need to order that postponement as soon as possible so that everybody will know we're not expecting people to go to the polls. And you need to update your contract for election services, if you have one, so that everything gets rolled forward to the November election. I will tell you that the Secretary of State has been communicating consistently and frequently with the counties about conducting elections for May. And those county election clerks are on top of it. They understand what needs to be done. If you need help with getting through this process, call them. If you're conducting the election on your own, contact your legal counsel, and they need to get you guidance on how to go through that process. Let's talk a little bit about continuity of functions, because ultimately that's the driver for this, is how do we ensure that we're able to continue to provide emergency response even during for the duration of this disaster, which is, of unknown duration at this point. So I want to throw out an option for you, and that is that your board president has the ability to adopt a disaster declaration, just like the county judge, just like the governor, just like the president. Has less impact, but they do have that ability. Under the Texas Disaster Act from 1975, you can declare a local disaster. it only is good for 7 days if the president adopts it. The board has to meet to extend it, and then the board can extend it for the duration. But the idea there is that the president says, here's what I'm declaring, here's what can happen, and the board then ultimately has to concur. So you're going to have to go back and have another board meeting in order to continue the disaster declaration. Well, what does it do? Well, a disaster declaration essentially declares that you've got a local state of disaster. You got to make sure you get notice to the public about that. I'd say to your media and your county clerk. That activates, and this is the language from the statute, appropriate recovery and rehabilitation aspects of all applicable local and interjurisdictional emergency management plans. I'm not sure how many of you have interjurisdictional emergency management plans to activate. So what good does it really do? Well, let me tell you that those plans can be activated, and one of the key components of that is what's called a continuity of function plan under Government Code 418-1101. That continuity of function plan can be adopted at any time. That's what the statute says. Treat your disaster declaration as a kind of bare bones continuity of function plan. What does a continuity of function plan allow you to do? That type of plan can provide for delegating any administrative duty of the governing body or any official or employee to another appropriate person. So let's talk about your administrative duties as ESD commissioners. You got to pay the bills, and you got to make sure those fire chiefs have access to their resources. Under a continuity of function plan that you can implement through a disaster declaration, you can authorize a board member to take those actions during the disaster. Now, the board has to, the president can do that in one fell swoop, and the board has to approve it after 7 days, but that can happen. And I think that will really help clear the path for your functioning as an entity during the disaster. You can set limits on what you're willing to approve within that document, but you can at least get things going. It can set up orders of succession for how things get done. One board member can no longer perform functions that were assigned to them under the disaster declaration. They can then, that can cascade down to somebody else, can establish meeting procedures. Here's how we're going to do these things. The one thing it cannot do is it can't provide for the delegation of a duty that the governing body or official is required to perform by the Texas Constitution. Now, for ESD commissioners, I will tell you there is not that much that you are required to do under the Texas Constitution. Everything that we do in terms of paying bills and all that is statutorily created. So this disaster declaration, serving as a continuity of function plan, can really help your district move along. So what we want to do with it, we want to authorize your fire chief, if the fire chief's an employee. If your fire chief is not an employee, I would authorize a board member that you all trust to do that, and I'd put a second in place so that you have chain of command. But you can authorize that person to make all the decisions regarding the resources of the district to respond to the situation. Physical assets, personnel, staffing, financial resources, all of those kinds of things. Now, some of you might say, oh my gosh, well, that's what our fire chief does already. Well, I guarantee you that if people don't like what your fire chief or your person is doing in this disaster, they're going to throw a fit. They're going to complain. This type of declaration puts that to it, just quashes it immediately and allows people to go, okay, that's what the board has said. This is how we're operating. Unique and special circumstances. We're moving forward with those instructions. So that disaster declaration can override, once again, that requirement that funds be dispersed by check signed by the treasurer and countersigned by the president or 3 board members. So we can override that with this. You know, that allows your district to continue to function without having you have to meet constantly to try and anticipate what the financial needs are or what the operational needs of the district are. Strongly encourage you to consult with your legal counsel as you craft that document so you make sure you cover all the things that you need to do. Now let me turn to revenue impacts real quickly so that you guys can start, if you haven't already been thinking about these things. This disaster could have impacts on your ad valorem taxes. The first thing we thought of was, hey, wow, we're going to get to use the old tax setting process if the disaster continues. And if it continues through that tax setting period, I anticipate that to be the case, that all the SB2 reform will essentially roll back to the old process at an 8% rollback rate. But the thing that's bad about this is there could be a reduction in taxable values if the economic impact of this goes on for too long and is too great. Property values could decline. You need to be planning for how are you going to deal with revenue changes over the next year. The world's going to be a little bit of a different place once we get on the other side of this, in my opinion. You also need to look at your sales and use tax revenues. People are stocking up on groceries. They're stocking up on some of those essentials. None of that is subject to sales and use tax. So the kind of, as people get, sheltering in place, there's less spending at restaurants, there's less spending at bars, there's less spending at stores. A lot of stores have closed down. Your sales tax revenue is going to decline. You need to get a handle on what that decline looks like. And if you are heavily dependent on your sales tax revenue for operations, you need to come up with a plan for how you're going to stretch those dollars until sales tax revenue comes back around. The other thing you need to consider is many of you charge fees for your services, and there may be some impacts to that depending on how the federal government, and in particular I'm thinking about Medicare, deals with paying people and just all those kind of things. I can't forecast what that may look like, but be aware that there could be some impact on your ability to recover revenue through those sources. I don't have answers on those things. I wish I did, but things to think about and pay attention to. Let's then turn to employee impacts. So the federal government, the Congress adopted the Families First Coronavirus Response Act recently, within the last, I think, 2 days. And that has altered some of the leave requirements. I am not an expert in family and employment law, and in fact, I've talked to Cliff and Clay about bringing somebody in to help with those of our ESDs that have employees, and maybe help some of those volunteer fire departments that have employees figure out how these changes are going to impact them. I'm going to run through these issues. I have no ability to answer detail on it because I just haven't delved into it that far yet, but I want to make you aware. The purpose of the act is to extend leave for people affected by coronavirus and COVID-19. So, an additional 2 weeks for expanded family and medical leave if you're an employee of a covered employer. I don't even know the definition of covered employer yet because the rules aren't fully in place. Extend, if you got to care for somebody because somebody else was affected by COVID-19, they get leave. And then potentially an additional 10 weeks of expanded family leave and medical leave at 2/3 of the regular rate of pay if they've been employed for at least 30 days. There's a lot of financial consequences to all this, and you need to make sure you're consulting with your attorneys about how this is going to impact your personnel decisions going forward. Here's the website that you can go to that's got more detail on it. And like I said, talk to your employment attorney about how this may impact your operations and your personnel requirements. Now, one thing I can tell you is that the governor, when he activated the National Guard, did do us a bit of a favor. He did exempt personnel who serve as first responders. So you were not going to lose workforce to the National Guard call up if those folks let their commanders know. So if you get called up or your staff gets called up, they need to immediately contact their commander and say, hey, look, this is what I do. Here's why I need to stay here and I can't respond. The governor specifically accepted first responders in this instance from call up for the National Guard. So recommendation is they need to go ahead and let their commander know. Be proactive about that. Hey, here's what I'm doing in my local community. I'm not going to be able to respond to the call up for the National Guard. That'll help keep your crews a little better full with folks that might otherwise be called up. So we're real close to 7:30, but I'm happy to answer more questions. Like I said, it's been a really wild ride over the last couple of weeks as all this has evolved. I'm sure we'll continue to try and bring you updates as we go. Clay, got any more?
Yeah, can you hear me?
Yep.
Okay, bunch of questions. I'm going to kind of string them together for time about shelter in place. Bear declared one today. You said Travis is probably going to do so tomorrow.
And Dallas did yesterday.
Dallas did already. What is shelter in place? If our ESD location is the fire hall and we shelter in place, does that mean the ESD is closed?
Yeah, so I wish I could tell you what shelter in place means in every one of those circumstances, and it depends on the details of how that order comes out. For the most part, my understanding, and I haven't read and scrubbed these because frankly, Travis County isn't under a shelter in place just yet, and none of my clients are in areas where they've had shelter in place declared until 6 o'clock this evening, where I now have to go read that. But in general, the shelter in place means non-essential personnel, people not doing essential functions, stay home. So, I think most of our ESD and volunteer firefighters are going to be out responding to the emergencies and taking care of the community. But most everybody else ought to be staying home unless they're going to the grocery store or trying to get medical care.
Yeah. One ESD commissioner in Kamal said, can the ESD commit? I think obviously, service providers, firehouses stay open, but can you have your ESD meeting? Are you going to get fined or something for going out to attend your ESD meeting?
So good question. I would argue that your ESD's continued operation is an essential governmental service, and we need to certainly take a look at whatever that order is or that requirement is in your county, and just make sure you're communicating with folks. I don't believe that the folks issuing those shelter in places are going to expect people stay home that need to be out doing the business of taking care of folks in the community. But that's going to be a case-by-case thing, and get that order when it comes out and talk with your attorney about how it affects your operations.
How do we deal with the noise level of all the visitors on the phone conference? Usually you could mute most participants, but that doesn't sound legal. You can probably mute them and reserve a time or some way for them to conduct. You don't have to leave their lines open the entire meeting, right?
And I would, in fact, argue this is almost like technology provides a benefit to meeting decorum and management, right? So essentially, if you can get your technology working for you correctly, you can say, okay, folks, I'm going to take one at a time. You let me know if you want to speak, and I'm going to mute everybody else so that we can kind of have this orderly conversation. There is no requirement that everybody be able to speak at the same time. They just need to be able to participate. And so what that looks like in a video conferencing forum is actually a little differently, because there's ways for folks to without being heard to say, hey, I want to say something. Maybe it's as simple as you give somebody a number that they could text when they have something they want to say about a particular item, and then you open up and unmute them in particular, or have them talk. The technology, I haven't done a lot of studying the details, but I think there are some options for that, and it's important to maintain decorum in your meeting.
You talked a little bit about property taxes during the emergency. Someone said they've heard that they might hold the same property values as last year. I guess that's if because the appraisals for 2019 have all been done and they're being contested right now, right?
Correct. So I haven't heard anything about property values being impacted yet. I think that's kind of something to keep an eye on.
Okay. Does the declaration override bank requirements for multi-signatures on checks if accounts are set up with the bank that way? If the ESD overrides multi-signatures requirements, will the bank be able to honor those checks if the account is set for dual signatures? So
I think that's something you communicate with your banker about, because essentially when you have that document, that order that's adopted by the district, that is a mechanism to authorize changing the signature cards for a limited duration. And so I would be in communication with your bank about, hey, we've changed our process as a result of this disaster, and we need you to accept these checks.
Do you have to do the disaster declaration to be able to pay without a meeting? You can still pay bills.
So yeah, some districts have in place the ability to pay routine bills, as they go forward. But you always have to approve your expenses at a board meeting, right? So either you're approving them because they've already been part of the budget and you're approving them at the meeting even though they've already been paid, or you're approving them in advance because they're going to be paid going forward. The disaster declaration actually creates an easier situation for expending funds. And I think you just need to be able to clarify that. Maybe your district gets by without having to have that authority put in place, but you need to think about whether or not there are expenditures that your fire chief or your providers will need to make without waiting on a board meeting.
Can the disaster declaration be done in an emergency meeting?
So I don't believe that putting a disaster declaration in place is in and of itself an emergency. An emergency meeting, and people, we talk about this all the time at safety. Emergency meetings are true emergencies in the sense that this has to be done right now, and there is no other way to solve this problem. Most of these financial requirements are 3-day kind of things. Now, remember, though, with a disaster declaration, the board president can put a disaster declaration in place immediately. The board then has to meet within 7 days. So I would argue that there's not an emergency for the board to meet to put a disaster declaration in place, because they're going to have had some notice, at least 7 days worth of time where the board president could have done that.
So the board president can just submit that order without a meeting.
Correct.
For the disaster, and declare disaster without a meeting.
Correct. And the board president really needs to talk to the council for the district about putting that draft together and getting that organized.
Right. If you have a physical quorum present, do you have to provide a way for the public to participate electronically?
So you don't have to provide the public a way to participate electronically, but if you're not letting them in your meeting room, you do.
Okay.
They have to be able to participate some way. And I'm going to recommend that you make that participation electronic rather than in person, lest you have more than 10 people or a really cramped, tight room.
Okay, it's 5 after 7:30, so let's go.
I mean, it depends how many more questions we got.
That's pretty much, I've gone through most of them. I do want to say something was offered. The Department of Information Resources, which is a Texas state agency, offers tools on tech and some technology providers that can do these kind of things. That's dir.texas.gov, Department of Information Resources. They're sort of the cyber unit of the cyber agency and information technology agency for the state of Texas. And they apparently have some resources that you may be able to check out for doing some of this video conferencing or teleconferencing. Yeah, that's the questions that I've seen. I'm not in the studio, so I don't have my producer telling me whether we're.
The last thing your producer told me was about the shelter-in-place orders in Bexar County.
We also got a shelter in Cameron County down South Padre area, down the valley, has ordered a shelter-in-place this afternoon.
Okay.
So let's go ahead and get to the credits. Safety is planning on a series of webcasts. We're going to keep trying to make these work, trying to make them a little bit better. So you can join us for those. We'll keep tinkering with the technology.